Hello and welcome to the Rogers Brief for May 13th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to be covering some stories out of the Nova Scotia courts this week and one case out of the Supreme Court of Canada, a family law case that I think you'll be interested in hearing about. So let's get started. Actually, before I get into the stories of the week, and for those that are new to the channel, that's what I do here. I cover legal stories that are relevant to those Nova Scotia, across the country, and sometimes internationally. I'm not going to be covering the Trump lawsuit this week. Sometimes we'll talk about American news, but probably heard enough of the Trump stuff and this civil case over the defamation thing I think has been probably covered fairly well already. I want to talk about some Nova Scotia cases. Police oversight was in the news this week. There's some judges, some appointed, some are retiring. I'll talk about that. The case, sentencing case of a prospective law student who was harassing a police officer out of Truro. Edwards versus Edwards. This is a case, family law case about custody and decision making involving COVID vaccines and an 11-year-old child. And then this Anderson versus Anderson case, big case out of the Supreme Court of Canada this week on the validity of separation agreements, which is always, well, it's been an open question for some time now. A lot of uncertainty around whether separation agreements, marriage contracts, these kinds of things are valid and enforceable. So before I get into that, people have been asking, if you follow the YouTube channel, you know that I put a book out last week. Nothing really to do with some of the stuff I cover in these videos, but people are asking about it and about whether there'll be any kind of a launch event. Don't have any dates or anything yet, but we're looking at something in person, but I'll probably also do a Zoom event. And so watch for that over the next couple of weeks too. We'll send out some times to have a Zoom event, maybe do a little bit of reading, answer some questions, you know, just try to let people know about the book and some of the process in writing it and all of that stuff. So let's talk about, we'll talk about that another time, but keep an eye out. So just a couple of some judicial announcements in Nova Scotia this week. 2 judges are in and 2 are out. This is in the provincial court. The 2 retiring judges are Judge Paul Scoville from, who's been sitting, I think, in Bridgewater recently. He was in Amherst for a while as well. And then the other is Judge Christopher Manning, who was based out of Kentville and Windsor. Both are going to be retiring. Judge Scoville is going to be still, it's like many professions. You can retire but then come back and do sort of substitute judging. So he'll still be seen around, but officially retiring. And 2 new judges had their robing ceremonies this week, and those are Judge Jill Hartland, who emerged, who's a year ahead of me in law school. I knew Jill fairly well, Judge Hartland quite well at that point. We did even a project together. So she's going to be a great judge. She was working as a federal prosecutor since she graduated law school. And the other is Bronwyn Duffy. Judge Duffy was working with Hector McIsaac and Craig Clark in Stellarton, New Glasgow, and practiced there. Did part-time federal prosecutions and lots of other court work as well. So she's going to be a quite capable judge. So some 2 down and 2 up. So some replacements there. Another story that was in the news this week, probably more so than the judicial appointments, was some stories in the CBC on police oversight in Nova Scotia and how different municipalities handle it. Now, the Nova Scotia Police Act, this was a big theme, or one of the themes out of the Mass Casualty Commission, was the lack of police oversight from civilian organizations. Now, the way it's supposed to go under the Police Act is, if you're covered by a municipal police force, then you're supposed to have a board of police commissioners appointed. And that would be mostly, well, civilian members from the community. It would provide oversight and guidance to the police that are in the area, including up to hiring the chief of police. Different in RCMP patrolled areas, but they're supposed to have municipal advisory boards. They don't really have a lot of control over which officers are in their municipality or who, you know, the staff sergeant might be, like the chief would be in other places, but still an advisory board with provincial appointees as well But what's happening is that many of these aren't set up, they're not functioning, they're not meeting, they're not taking minutes. Some of the cases they don't even have a board, or else it's just council, municipal councils that are taking over the function. And so what's happening? I mean, in the Mass Casualty Commission, one of the things came out of Halifax certainly was that these boards of commissioners are under-resourced, so it's citizens that don't really have a lot of free time. They're volunteering or they're getting paid very little, and they don't have time to digest everything that's coming their way and make informed decisions about policing. So that really is something that needs to be changed. That's probably not going to happen if you're reading between the lines of the provincial government reaction. Excuse me, the provincial DOJ, Department of Justice Minister, is saying that they're preparing letters to send out to municipalities, and they said that this was in reaction to the CBC inquiries about municipal oversight boards. So they're going to be sending letters out to make sure everybody has that in place. So what does that mean? Well, in reaction to the Mass Casualty Commission recommendations, which was to provide, much more robust oversight, it looks like the province is satisfied to tinker around the edges, just do the minimum necessary to comply with the legislation and not really look to police oversight overhaul. So that's the message with that as I'm reading it. Okay, next story. It's a case out of Truro, and actually those that listened last week, I covered this case, dangerous case with guys taking a police car. Pike was the name of that one. We have the same people involved, same judge, same Crown, and same defense counsel in this case, which is King versus Minugh, M-I-N-U-G-H, Minugh, I guess, or Minugh, I guess I'm going to say. So Judge Bejan of Truro, Crown Thomas Cater, and defense lawyer Nick Hone from Legal Aid in Truro. And this was a sentencing decision, but it was interesting because it involved one of the main officers, or one of the more, I guess, prominent officers from the Mass Casualty Commission circumstances. That was Constable Nick Dorrington. Nick Dorrington, who I think my assessment of it was that he was an all-star officer that was kept on the bench during key moments and not utilized to his full capacity. This was a former military, he was in the military, had a lot of skills, and he was actually the person who had given Wortman a speeding ticket about a month prior to the shootings, and so was able to provide his photograph to other officers so that they could at least be aware if they encountered the man, but testified, I thought, very, very well at the Mass Casualty Commission and carried himself well throughout. Well, here he is, this Lee Minugh. The facts are that she was charged and pled guilty eventually to section 423.1 sub 1, which is conduct intending to provoke fear in a justice system participant. Justice system participant can be a police officer, a lawyer involved in court cases, or a judge, or even a court staff person. And so it happened while Miss Minugh was a passenger in a vehicle, and where the driver had been arrested for impaired driving, there was another passenger who left. The Judge Bézange says, made the smart decision to leave the scene of her own accord, but Miss Minugh, whose judgment was clearly impaired by alcohol and for reasons known only to Miss Minugh, chose to stay and harass and threaten Constable Dorrington in vile, vulgar, derogatory, inflammatory language. By the way, this was all captured. Constable Dorrington had his body cam activated, and so this was all captured. It says, not simply a few words by Miss Minugh directed towards Constable Dorrington, but a repeated, visceral engagement that goes on for approximately 10 minutes. And some of the statements were that threatening to make a sexual harassment complaint against him, calling him a baby killer, asking him and making a threat, do you have kids? I will pay them a visit. Do you have a wife? I will call her up. I will find out where you live. Threatening his deceased daughter. Tell your daughter that I will see her soon. Use the B word. Calling him a piece of shit. White privileged. Tried to antagonize him by saying you're going to shoot me. Calling him a dork and a dick. antagonizing him by saying Black Lives Matter, talking about woke culture and anti-police. So that was anyway quite an encounter, unprovoked. Constable Dorrington had done nothing to provoke the reaction in any way, according to the decision. The pre-sentence report done, which is a common thing done in a sentencing case, especially where there's a risk of jail time, that a probation officer talks to people that know a person and prepares a 5 to 8 page or so report on them, their background, all that stuff. In that it says that this Miss Minugh has trouble with mental health, with anger management, and with alcohol. And she's started private therapy. She's looking to attend law school. Well, I think she's going to have trouble there, especially after this decision. In law school, not so much, but when you emerge from law school, if you want to get admitted to the bar in any province, there's a number of things you need to do: pass the bar exam and all those things, find a spot to work. But there's also a good character requirement, and it's not always 100% clear what that might mean, but something like this where nothing good about this from her perspective. The judge didn't accept that she had she was trying to blame the alcohol. The judge says if someone knowingly has a problem with alcohol, she should avoid drinking alcohol and not just assume whatever happens after she drinks alcohol is not her fault but the fault of the alcohol. The other problem, she didn't have great respect for the court system either. She had to be picked up the day of her trial by the police. I'm sure that was a good drive to the court. And in her pre-sentence report, she said to the author of the report that she wanted to write an apology letter to Constable Dorrington, but the judge notes that she did not do so. So the Crown was looking for a 30-day straight time jail sentence. Defense was looking for a conditional sentence, like a discharge. Judge ordered 3 months of very strict house arrest, followed by 2 years, 24 months of probation. So that was the outcome in that case. And I think there'll be some major consequences if law was indeed her goal in life. Then she's got a lot of work to do before she gets there. Okay, 2 family law cases I want to talk about to wrap up. One is a Nova Scotia-based case. The other is a Saskatchewan case that went to the Supreme Court of Canada. The Nova Scotia one is interesting, although now that the World Health Organization has declared COVID over, maybe less relevant, but if anything else like this comes along, it will be. So this was a decision from Justice Jollymore, and it was a Halifax-based case. A couple who had separated in 2018 and had at that time a corollary relief order, a judgment that said that both must consent on the medical attention that their 11-year-old daughter is to receive. Well, okay, what happens? What about the COVID-19 vaccine? What happens there? The mother says no, and so the father applied for an order that he would be granted sole decision-making authority in that circumstance. So first thing you have to do when you're looking to change any kind of a divorce order, corollary relief order, is to say, well, has there been a change in circumstances? There's 2-part test. 1, has there been a change in circumstances? And 2, what's in the best interest of the child? So the change in circumstances, the judge said, well, yes, there's been a COVID, there's been a pandemic, and the public health advice has been for children to be vaccinated. So that has been a change in circumstances, according to the judge. It's not always obvious. I mean, circumstances evolve and change all the time, but it has to be a significant change. The judge was very critical of the mother and her lawyer, who's Brian Murray from, I think from Boyne Clark, for misstating the law, the test on from the Divorce Act on that point of change of circumstances. On the best interest of the child part, the second part, which was the key element here, the court pointed out that the mother used to be an infection control nurse, so not somebody without knowledge of medical situations, and has done her own research. Okay, that old thing, right? Done her own research. Believes in natural immunity, which the judge points out didn't quite operate properly here because the child, the 11-year-old daughter, has had COVID twice. So natural immunity didn't come through. The judge accepts the public health advice. Hard for the judge, so difficult, not a difficult position for the judge to be in, kind of a simple one in a way. You have somebody doing their independent research who, is not just some random person off the street with no education, somebody that is, has a little bit of knowledge, but a little bit of knowledge can be a dangerous thing, I guess. In this case, the little bit of knowledge wasn't satisfactory to the judge. Whatever, you read stuff from reputable publications, that doesn't balance that against the public health advice, which, sure, it's evolved, but it has not evolved in the sense that throughout the pandemic, public health was advising that children should be vaccinated. So the judge took that, and the result was sole decision-making authority on health matters to the father. So something to watch now. If this, if there's a serious public health situation and the prevailing public health advice is one thing and you think it should be another thing, then this is a case which could be held up as an example for people following public health advice, and the courts are going to back that up unless there's something very compelling on the opposite side, which there wasn't here. All right. Last case I want to talk about, and this is out of the Supreme Court of Canada. This is a case called Anderson versus Anderson from the Saskatchewan Court of Appeal. And a situation I see all the time. Actually, I dealt with people this week, and you sign a parenting agreement, you sign a separation agreement, you sign a marriage contract, all these things that, all right, if we separate, here's how it's going to go. Or now that we've separated, you take that, I'll take this. Here, people sign these agreements. Well, they get attacked all the time. And why? Because if you haven't received legal advice, then so-and-so, they gave up their rights to a pension, their spouse's pension, or they, accepted the vehicle in exchange for the house, and boy, that seems unfair. And, all these things that in retrospect, after a year or two, sometimes people want to look back and say, well, that wasn't fair, I was stressed out, I was still, going through a lot of emotions, and didn't get legal advice and signed something I shouldn't have, and so we should toss that agreement out. And it was happening fairly often, and there was a lot of uncertainty among lawyers certainly about what do you do, right? Can you just get people to sign an agreement, or do you need to put them through the time and expense and trouble of going and getting independent legal advice? Well, this is answered fairly clearly from the Supreme Court of Canada that these agreements are valid. All right. In this case, they did not have legal advice. Mr. Anderson, the husband, argued against the validity of the agreement, saying that he didn't receive legal advice and he felt stressed. He was under duress when he signed it. The trial judge in Saskatchewan agreed and divided up the property without considering the agreement, ordered the wife to pay $90,000 in equalization to the husband. The Saskatchewan Court of Appeal overturned that decision. Using the analysis from a Supreme Court of Canada decision called Miglin, M-I-G-L-I-N, and that was the one that talked about, how agreements could or might not be valid based on independent legal advice, duress, all these kinds of circumstances. So in that case, the Saskatchewan Court of Appeal said the agreement was binding and ordered the wife to pay not $90,000 but only $5,000 in settlement of their property. Supreme Court of Canada agreed that the agreement was valid. Sorry, they said that the agreement was valid. It was a short, uncomplicated agreement and reflected the intention of the parties to make a clean break. This is what people want to do many times. They, all right, we're done. Let's just sort this out quick and easy, or not. Sometimes rough and quick as a settlement. You're not working with exact figures, but all right, just get it done and agree to that, and everybody's happy enough and moves on. The court says that domestic agreements should be encouraged and supported by courts, that the principles of self-sufficiency, autonomy, and finality are important. People want those things. And then the courts cannot presume that spouses lack the agency just because the agreement was negotiated in an emotionally stressful context. All right, you're separated, it's a new life, it's going to be emotional, it's going to be stressful. You can still negotiate as an adult under those circumstances. Supreme Court of Canada didn't follow exactly the Saskatchewan Court of Appeals financial outcome. They went with $43,000, so about half of what the trial division ordered. I suspect that both parties probably spent at least that much in legal fees going through 3 levels of court. But there you go. Ultimately, the Supreme Court of Canada ordered that the wife would pay $43,000 to the husband in settlement of their affairs. So there you go. But the good news for everybody across the country that's involved in the family law and couples that are looking to separate and looking to do it without the complications and the expense of going for legal advice, then you can do so, and you can count on it being upheld by a court in the future. All right, so that's everything for this week. Keep it short because everybody should be, well, not everybody should be, but those that are celebrating Mother's Day, I wish you a happy Mother's Day. Those that are able to celebrate, and we'll be back next week with more from the Rogers Brief. We'll be back on, I believe, Sunday night as well, tomorrow night with Jordan Bonaparte and Paul Palango on the Nighttime podcast at 9:15 p.m. and doing live on YouTube, followed by a podcast version as well. That'll be released in a couple of days thereafter. So until then, or until next week, if you're watching the Rogers Brief, thank you for watching, thank you for listening, and we'll see you next time.